Jackie Dean.
Mr Speaker, the Evidence Amendment Bill, first reading, this bill is going to the Justice and Electoral Committee, and I'm very pleased as the Chair to be sent this bill, along with the Harmful Digital Communications Bill, which has just very recently passed through this House, indicates a general move by certainly the government and supported in this instance by many parties around the House. We'll find out how many parties around the House, is showing a trend towards a greater protection for victims of crime. And so, if I might just divert very slightly off the bill for a very short time, Mr Speaker, the Harmful Digital Communications legislation will protect young people, give them a measure of protection in law and in practice from cyberbullying. This Evidence Amendment Bill, of course, is a different beast and gives legislative protection for children who are victims in terms of giving evidence and cross-examination in the court. So, as the previous member, David Parker, and his very thoughtful contribution, and I thank him for that, to this debate, noted, this work does come out of work of the Law Commission, which was commissioned by the then Minister of Justice, Judith Collins, in 2013, and this bill picks up most of those recommendations, with one or two of those recommendations altered slightly, but in essence, the Law Commission's recommendations have been picked up in this Evidence Amendment Bill. The main provisions in this bill are to make changes to improve the court processes for vulnerable witnesses. Clearly, most of those are children. At the moment, prosecutors have to apply to the court to use alternative ways of giving evidence, and an application must be made, and then the judge has to then consider and give permission for alternate ways for evidence to be given on behalf of children. And commonly that will be for the child to be, or young person to be, supported by a family member or representative, and perhaps for a video conferencing method to be used to give evidence. So the presumption in this bill will now be that child witnesses give evidence in alternate ways, and so that will be up to the child's counsel and the child's support person as to what kind of degree that child can be exposed to the courtroom in order to get the best evidence from that child. Fundamentally, that is a very humane way and a very humane change to our court system to minimise the stress on children and any long-term impacts that, let alone the offending, but then the reliving of that offending in the court processes. The restrictions on video records evidence, again, is supported by the Labour opposition, and I can only reflect that David Parker, as a not practising now but former lawyer who has been, no doubt, through this process on behalf of some of his clients, again is in agreement with this provision. I do hope the rest of the House are. And as I was preparing for this speech, Mr Speaker, I didn't quite have time to go back through the legislative changes that this government has made, but it brought me to mind of some other changes we've made in a former piece of legislation where this type of information is again restricted. And the case I'm thinking of is where a victim's contact details, address and phone number were able to be shared with the offender by the offender's counsel. The offender was then able to recall those, remember them, and harass that victim from inside prison. And I won't make a stab at what the legislation was. It was a few years ago now. But again, this provision in this evidence bill is in line with that further protections for witnesses. Nothing else. It's not a mechanism for preventing information to be shared with the Defence Counsel. It is rather a measure for protecting witnesses. The Minister, in her opening comments, outlined the privilege for plea discussions and the provisions in this bill which extend the privilege that currently applies to settlement negotiations and mediation in civil proceedings under this bill will include plea discussions in criminal proceedings. So, at the moment, there is no clear privilege in this matter in respect of communication in plea discussions. Again, the Law Commission recommended reform in this area and has been picked up in this bill. Again, admitting previous consistent statements into evidence. And I think here the previous member who was speaking rather glossed over perhaps some of the consequences of the 2006 amendment to the Evidence Act in saying, oh, well, we don't always get everything right. No, we don't. And this is an opportunity in this bill to reinstate the provision for consistent statements to be entered. And perhaps an example of that would be if a complaint was made in a criminal case, maybe a complainant, a child, told their mother that they had been raped, consistent evidence of a 111 call made on the day or night of the occasion of that alleged rape could then be used as supporting evidence. So, yet again, another good inclusion into this bill. There are also a number of minor and technical amendments in this bill which the Justice and Electoral Committee, together with other parties in the House, will go over. So, Mr. Speaker, I just want to finish my initial contribution on this bill to again say that it is another piece of legislation brought to the House over the past 7 years which puts the victim of crime at the centre. In this instance, it provides protections for child victims so that they can give good quality evidence, and that's the key, good quality evidence to the court, but without re-victimising or further victimising or traumatising themselves, provides clarity, more clarity to the court around evidence to be introduced, which is consistent with the original statement, and also provides for notice requirements for evidence of previous sexual history where a notice must be given to the court if a previous sexual history is to be entered into evidence. And with those words, I commend this bill to the House. Thank you.